But I don't know how many people come in and say, "Oh, parental alienation." I'm like, stop, go away from Google Lawyer. Let's
Yep,
reframe
yep,
the
yep.
conversation. And here's how we need to make those arguments. But it does exist. And that's our job, right? As the lawyers, is to be strategic in how we present it to apply to the best interest.
And a lot of folks, I think, lose confidence in the system once they see a judge they've had a bad experience with caught doing something wrong or charges filed, and then ultimately nothing happening.
I went through and did the statistics. She was awarding on temporary orders, which are non-appealable, as we all know. 88% of the time she was giving primary custody to mom. And I did the math.
Alex here with our first Perspectives panel. We've done a number of Perspectives videos in the past, but it's always involved one interviewer and one interviewee. This time we have a panel of 3 family law attorneys, 2 of which are from District 2, Washoe County, and one of them which is from District 8, Clark County. I wanted to clarify one point before we start. Finding fresh, important, and relevant topics is sometimes one of the trickier parts of coming up with a good Perspectives video. And this time, we decided to use a number of bills that were proposed to the legislature. Whether the bills themselves actually pass or not is not as much of a concern as the opportunity to introduce you to the panelists and to dive into the topics themselves. I want to mention 2 major edits. The first is that my microphone had an issue recording during the first half of the video, but that's okay. I'm not one of the panelists anyway, and I didn't participate in the discussion. All I did was raise the questions on the topics. The second has to do with a portion where I discussed the Our Nevada Judge's website. We already have a separate video dedicated to this topic, so I removed it. And if you'd like to learn more about the website, you can click on the sliding card here if you're on YouTube, or if you're on Facebook, you can go down into the description below and click on the link. Let's move on to the introductions, starting with Lance White.
Good afternoon. My name is Lance White, and I am partner of Wittes & Whites, and I've been licensed for 14 years, and I serve as a court master up here in Washoe County for about 7 years.
And Andriea Aden.
Good afternoon. My name is Andriea Aden. I am a certified family law specialist practicing in Washoe County. I currently own my own firm that I opened 4 years ago, and I've been licensed in the state of Nevada and practicing since 2008.
Over to Mel Grimes.
My name is Mel Grimes. I am a attorney in Las Vegas, Nevada, primarily in family law. I also do personal injury. I'm I think I'm the newest attorney on this bunch, even though I think I'm the oldest. I was licensed in 2013. I spent 22 years before that in education. Decided to retire, and when my wife decided not to retire with me, I went to law school. So that's what happens when you get bored.
The first topic has to do with child support in joint physical custody situations, brought to us by Senate Bill 133, which had proposed to have it. Let's start off with Lance White.
Well, I have been a child support court master up here in Washoe for about 3 years. And one of the areas of law that was always frustrating is that you had parents that had joint physical custody, and it seemed as though they are always going back to court every 6 months or so in hopes of lowering their support back and forth. And so I know there's been movement before to lower this in these types of situations. I think it's getting us closer to being able to say, well, you have joint, I have joint, let's not pay each other child support, which, depending how you feel about that, it looks like it's the goal of a lot of legislators. I know that child support and the enforcement of it federally was created to make sure children were provided for. It's not to be considered a tax. And so I always had an issue giving someone a bonus where maybe they didn't need the money, but because of the statute, because of the math, it worked out to where they got a bonus for being a less earning parent, even though their lifestyle might have been a better one. I don't know.
Going over to Andriea Aden.
Yeah, reading the statute, I found it interesting because of the language of shall, and that it would be a mandatory application. There was a lot of work put into the new child support guidelines that just went into effect last year to finally add in some discretion to the child support, giving the judges the ability to really truly look at the best interest of the children. And the big paramount factor now that they look at that I've heard from judges is really a party's ability to pay, and as much as the formula that they look at. So what concerns me about this is the shall language and that it being mandatory, thus ripping away the discretion that the judges were just given. But I will say I have a lot of clients who would love it. They would absolutely love it. So it's a tough one where if they have joint, should it be nothing? Not in every case. That's family law is so fact specific. I think it's hard to have a statute that doesn't allow for any discretion.
Let's see what Mel Grimes has for us.
Well, that was a nice segue because both of you guys are up in Reno, so I don't know that our paths have crossed much, if at all. But I am actually of the position after the 2020 or the 2010 census that child support is now unconstitutional. And again, everybody gets caught up in the discrepancy of incomes between men and women. But as of the 2010 census, women are earning 98% of what men are earning when you balance the perception and you don't take all women and all men. You have to look at attorneys versus attorneys, doctors versus doctors. Yet 88% of all child support is paid by men. That's a violation of the 14th Amendment. That is a violation of equal protection under the law. And so I think we get caught up in the best interest of the child far too much and not in what is correct. We no longer look at fault in divorce. We no longer look at conduct. We now have case law that says we don't even look backwards in a marriage. We only look at where it is today. So the Rivero decision, a per se primary is, in my view, thrown out at this point because anybody can step in and go, well, that was the case while we were married, but I'm available 147 days. I can provide. And Andrea, you brought it up. I think I guess it was Lance who talked about it as the hearing master. It's a constant battle over this money. Remove the money. Just remove it. You can either care for the child or you can't. And I think the easiest argument is in joint physical custody. Now, I will tell you that I actually think it ought to be applied to both primary and joint, regardless, and remove the money from it. It is not a popular opinion. And obviously, I have clients who have a differing view. Our job as attorneys is to represent our client's view and not our own. But when we're in situations like this, it's a discussion I think has to be had. And I don't think I'm alone, but I do believe I'm in the minority.
Appreciate all three perspectives there. Moving on to sealed cases and closed hearings. Senate Bill 334 appears to expand existing law, at least with respect to closed hearings, which originally only applied to divorce actions. SB 334 appears to want to expand that to any child custody matters. And there also appear to be some technical changes to survivor benefits. This is not an area that I have a tremendous amount of knowledge on. So go ahead and Lance White, take it away, specific to whichever you feel comfortable with, whether it's sealing cases, closed hearings, or survivor benefits.
Well, I'm going to leave the survivorship portion to Ms. Aden because I know that that is a personal love of hers. I'll let her discuss that at length. However, in regards to the sealing, I think this is just another hope that the court can avoid the public's view of what they do. Now, I understand that none of us, if we could get away with it, would want to be observed by the public in our jobs. It can often be uncomfortable. Often people aren't educated in the ways of the law of the court and come away with the wrong opinion. But you're asking the public to give you something. You're asking the taxpayers to give you something when you go to court. And to thereafter say, well, I don't want the public to see what's going on other than the pleadings. And frankly, and every practitioner knows this, the pleadings tell you nothing about a case. Maybe some names, maybe some date of birth, and that's nothing. So when they throw it in these statutes like it's a big deal that these will always be available, it is not a big deal. They're meaningless. We're a notice pleading state, meaning there's no information in there that could be of much value to anybody. So I think the public has a right to have access to those sorts of things unless it involves a child or something of an unusually sensitive nature. But to have the default to be sealed, I think that's just an opportunity for the courts to avoid any kind of real scrutiny.
Thank you, Lance. Over to Andriea.
It's an interesting point that you bring up, Lance, because when I read this, to me, I'm going, this isn't really much different than actually what happens in practicality and what I'm seeing in courtrooms, in that I don't have a lot of people showing up. I mean, now we're in Zoom land with court, but if somebody walks into a courtroom, you'd go, who are you and why are you here? So I don't see a lot of people randomly just showing up to family court, but I appreciate your point on transparency in the court having to have those open courtrooms, but also balancing the need to have privacy protected in really difficult cases if there are allegations of domestic violence or child abuse or things of that nature. And we're able to do that now under the statutes. This basically makes it a little bit more automatic, and then you kind of have to unseal some of certain things. Is how I read it. It was interesting. But I mean, I don't really have a strong opinion either way. In practicality, I don't think it would make one bit of difference in how I practice. And I would pursue to see those cases that I already would pursue to seal. I think it would be interesting to have to ask the court clerks on their opinion, having to keep track of which documents now they have to seal and not seal. So that could be fun for them. But yeah, on the other part of the statute that I read was adding in very specific statutory language on dividing retirement accounts and specifically survivor benefits. And to give you guys some background on where that comes from, there was some case law that came out recently that basically said, if in a divorce you do not specifically include survivor benefits, it is waived. You cannot come back and ask for it later. And a lot of people were scrambling, not realizing that they needed to ask for that. And then, I mean, once a property division is final in a divorce case, you know, barring some sort of crazy fraud situation. So, I mean, I have those clients that think their retirement is theirs and they don't want anybody to touch it, so they would hate this. And I have those clients that want every single cent. So again, it's just fact specific on in each case, but at the end, community property law controls. It seems a little overkill on that part.
Back to you, Mel.
So, Alex, you know, I've taken on some rather high-profile cases that, whether they're sealed or not, they seem to end up on YouTube. I am not a fan of sealing cases. I believe that the courts, not necessarily the cases, need to be open and transparent to the public. So I think the onus is on the litigants and not the statute. I think the litigant needs to come in and show good cause why the case should be sealed, not automatically assume it should be sealed and show good cause why it should be open. You know, probably the biggest one, only because of some of the local troublemakers here in family court. We had mental health records of an 8-year-old kid, and his treating psychiatrist come in and testify. All I wanted was that portion sealed, and Judge Pomeran sealed the entire case. And it's created headaches for me ever since. I actually want everything open. I want the public to be able to see. I think that takes away power. We talked earlier about some of the litigation that is being filed against you or threatened against you. These guys use that sealing to say, you're hiding stuff. I don't want anybody to be able to say we're hiding anything. I operate ethically. I take the rules of professional conduct, the rules of civil procedure. I take all of the rules very seriously and the obligation on me. So open it up. Let the public see it, unless there's good cause for the public not to see it, like a child's mental health records.
Another great round there. Going into our next topic, we have family division input on the Commission on Judicial Selection's appointments. This one comes to us from SJR2, and I believe Lance White has already touched on this in a previous perspectives video, but we're going to go ahead and go through it with this panel so we can get we'll get a rehash from Lance White as well as the perspective of Mel Grimes and Andriea Aden. Starting off with Lance White again. Go ahead.
Well, again, this seems like it's a narrowing down of how much the public that are not law trained have in their ability to influence who's appointed. And certainly, I would like a person being on that committee to be at least conversant in the area of law that they're going to place the person. But reducing the number of lay people, well, I think, again, that's just to winnow down the amount of true public interaction influence. And I think it gives a extra amount of authority to the current judges, selection committee, lawyers to influence one layperson on a committee. I don't see how it'd be possible or practical for anyone, just a one layperson on a committee, to say, no, sorry, Justice so-and-so, sorry, lawyer so-and-so, I think X. So what you'd get is you'd be able to say you have a layperson who would essentially, I think, in more cases than not, kowtow to the groupthink.
Thanks for bringing that up, Lance. I forgot to mention the bill does propose reducing the number of laypersons to one. Over to Andriea.
Yeah, that's an interesting point. I was more looking at it adding in the requirement that they have to practice in that area of the law, which I kind of liked, as opposed, in our family law community up here in Washington County, it's small and we all know each other and practice with each other. And I would love to get input on certain things, especially when it comes to appointments. That even could go into the election process of judges, which to me still is just kind of crazy. The public does not know what they're voting for. But with the appointments, yeah, I think that there's a balance to be had, right? We need the experience and those people that understand and know these individuals and know how they practice or know what they've done in their career, and then also have the public input as well. I mean, it's Reno, it's a small town, everybody knows everybody. But then I worry about, especially in family court, if that one person had that one judge and they had that bad experience, but actually they're overall, or had that was the opposing attorney in their case, and now they want to be a judge. So I don't know where the balance is to be had there. At the end of the day, I think it's good that there is input from other individuals and it's not, just one person making the decision, that there is this committee that exists. So the fact that exists, I'm happy to see, but definitely I think some fine tuning could be had.
You had Mel Grimes cracking up there. Let's see what he's got for us.
Well, elections. I really struggle with electing judges. I mean, it's silliness, but that's not really what we're talking about. So I actually, because of my background, in Oregon and then also in Arizona, I served on appointed committees as a lay person in different areas. I think most lay people take those appointments fairly seriously. They do their research. I'm not worried about that. I'm more comfortable with our appointment process than I am our election process. These two are both from Washoe, and I'm assuming, like down here, it is a small community, especially of those who practice it regularly. We all know each other. We hang out together. And when we walk through the courtroom doors, we enjoy nothing more than pounding the living snot out of each other. And so the reality of it is, yes, we know each other, but I don't know that makes a difference. You still got to put the application together. You've got to know the issues and know the law. There's very competent lawyers that I go up against that I'm astonished. They're still quoting statute that was changed and codified in 2017, and they don't realize that the entire statute changed. I have attorneys that I have a lot of respect for that are still citing old case law on relocation instead of citing 125C. And they want to argue, well, mom can't be tied to the state. Well, that's old case law. That's not the law anymore. And I struggle with that. And I think if you're going to be a judge, put together your application packet, be prepared for the interview process. And I honestly would not care whether or not there was an attorney on that committee at all. My experience with those committees is those people take those appointments seriously. They read the information, they do their due diligence, and they take that interview process very seriously. And then ultimately, it's the governor's call. I don't know how many have been appointed up there, but prior to our last election, I watched 3 get appointed where the governor one of the three appointed the first choice coming out of that selection committee. Other than that, he went other ways. He chose from the group, but not the number one. So I don't really care what that committee looks like. I like the committee idea, and if they want to revamp it and include more or less, I actually don't really care. I know that sounds awful. I just don't. I think what we get appointed is better often than what we get elected.
All right, going on to judicial compensation. Senate Bill 3 proposes raises for the justices of the Supreme Court, the Court of Appeals judges, and the district court judges. There's also how they contribute to their retirement packages. Let's head over to Lance.
I think I read this correctly, that the increases in their salary will be tied to some kind of index in the future, which I like, instead of leaving it to the whims of whoever is maybe in the governor's house or whoever controls the legislature. I like that. We're talking about a lot of money. I mean, what they're paid now is not small. It is not a public servant wage. I understand that they work hard, but I think that's awfully high still. And I think that if we were to look for some other avenues for income stream to maybe bolster those salaries, would be better than simply raising taxes. I'm a fan of maybe winnowing down the senior judge program, which is turned out to be a supplementary retirement insurance for judges, and I think we overuse it. And so if we can save some money in some other areas, then certainly. But I don't think what judges make now is anything that would deter them from running for judge. And if it did, then, if it was the money that kept them from applying or running for, then that says something about their aptitude for the position more than it does about the amount of money we're giving them.
Over to Andriea.
Yeah, I thought that was interesting. So anytime people ask me, do you ever want to be a judge someday? And my really bad joke is, well, I don't want the hours and the pay cut. So when running your own firm, right? We work all the time though. But I don't know. I feel I was surprised when I would look at Transparent Nevada and see what judges would make, to be honest. It's since, kind of think gone up with in time, but this kind of increase statutorily, I thought was interesting. I'm not a judge. I've never served as a judge. I have no plans of ever being a judge. But I know that they have to do full day calendars, plus read motions, deal with emergencies. They put in a lot of work. And I think the current judicial judges that we have in Washington County are putting in that work, which I really enjoy seeing. My question or concern is we are going to be facing massive budgetary shortfalls because of the pandemic, with the casinos being shut down and all the tax revenue that comes from there. So my question really was, where is this money going to come from? And if we're looking at picking where this limited money needs to go, where should it go? I don't have an answer to that. That's just what I thought of when I read this is what makes this a priority more than other things that we need to help with in our state.
What do you think, Mel?
Andriea just hit on my issue. I think they're underpaid. I think we've got to look at that. I think this legislative session was the wrong one. There is just no chance that we have the money to do this. And what limited funds we have are going to be eaten up recovering from this pandemic shutdown. So it should not have been in this legislative session.
All right, moving on to the Commission on Judicial Discipline, specifically brought to us by Assembly Bill 43. The bill originally proposed to curtail some of the Commission's investigatory / prosecutorial powers. The interesting part that Lance White specifically wanted to discuss was two of the letters sent to the legislature from Executive Director of the Commission on Judicial Discipline, Paul Dela.
Well, I think that the Ethics Committee have a tough job, and I think they have a difficult job policing a branch that is essentially appointed for, as long as they want to stay, essentially, with incumbency advantages. To do it in a private way but still respect due process, it's difficult, and as we see, almost never does a judge get removed. What they do get is they get some kind of public reprimand, and really it doesn't do much. And so I think there's a lot of effort there that doesn't really end up in a lot of heat, but there's a lot of smoke on these things. It goes on the website, people talk about it, it's exciting. I think they do a better job of removing, like, for example, hearing and court masters, because essentially those are hourly employees that the court could get rid of anyway, but they choose to, I think, send it over to the Judicial Ethics Committee. I think more transparency would be good, and I think if there were some real, I don't want to say punishments, but consequences for the judicial branch, I think you'd have to do that from a statutory or even a constitutional standpoint. Because right now it's a lot of work for very little effort at the end of the day, and a lot of folks, I think, lose confidence in the system once they see a judge they've had a bad experience with caught doing something wrong or charges filed and then ultimately nothing happening.
And before we go over to Andriea, Aden, just in case you haven't reviewed the letters that were submitted to the legislature, instead, if you feel like you still want to cover or discuss this topic, just maybe you can touch on some of the damage that former District Court Judge David Humke caused to the judiciary there in District 2.
Yeah, no, I haven't seen the letters, but I can comment on this just from as a practitioner and specifically on the impact of Judge Humke. And I think that for me, the two kind of go hand in hand. And one thing that Lance said that really hit home for me was transparency. Is I'm a practitioner in family court. I'm in family court all the time, but I feel like I have no idea what's going on with the judges and if there's complaints filed or even how to do that. And if I run across that scenario, what is my recourse? Because I practice in front of these judges every day, and there's fear there of repercussions if you were to pursue anything. And then also, I mean, am I being an overzealous advocate here, or is this something really that crosses a line? And if I have those situations, we have the State Bar Hotline, which is always great to call if we have ethical questions or concerns. But at the end of the day, I feel like it's a David versus Goliath type of situation, and I feel very much inhibited and able to do something. Not that I've really had this issue come up a lot. I will say that I'm not contemplating, the judges acting unethical. Now, with Judge Humke, that was occurring, and all of us judges were experiencing, us attorneys were experiencing that with him for a long period of time. And it was beyond frustrating what was occurring there. So glad that was finally resolved, and we have, a good judge in that department now, a great judge in that department. But it's a frustrating and scary area of what I do in if you have concerns about something that's going on. What do I do? What do I do as a practitioner for my clients, or even just as a lawyer with an obligation to report to the state bar, where that's a really tough line.
I can say you're not the only one. A lot of our sources have the same fears that you have. Before we go over to Mel Grimes, the same issue, you can go into the topic generally, or if you'd like to, you can cover the damage caused to the District 8 judiciary by former District Court Judges Stephen Jones or perhaps Elizabeth Halverson.
Well, I came in as Halverson was going out, so that, if you don't mind, I can actually talk about two that are related to these topics, especially since Andriea brought up the fact, what do you do? I'm in a beautiful position of, unlike a lot of people, all I've got to do is make sure my staff gets paid. I don't have to pay for my home, and I'm in a very comfortable position. But I had a run-in with a judge, a longstanding, now retired family court judge, who I went through and did the statistics. She was awarding on temporary orders, which are non-appealable, as we all know. 88% of the time she was giving primary custody to mom. And I did the math. I did every case because we have public records. And I took it to the chief judge and I took it to the Judicial Commission. When I appeared before Judge Bell on the issue, she was astonished at those numbers, and her response was, I would like you to do more of the family court judges. Thank you, because you bring up a concern, they give you homework. I simply could not do them all because we had too many here, but I randomly we just threw every but judge's name in that did divorce and custody, and we drew 3 more out and went through. And this particular judge was more than double anybody else of simply giving custody to mom. Went to Judge Bell, who then ordered me to bring in a statistician and review all of the numbers using stats. And she fell 0.1%. Yeah, 0.1, so 0.1% inside of the standard deviation. Thus, there wasn't a problem, and they dismissed it at the chief judge level. And I took it to the Judicial Commission, and the Judicial Commission refused to even investigate it. So it is a David versus Goliath. They get away. They have unbelievable power on that bench, and it's troubling. So the other one, and this was an election issue because I came out and I endorsed a number of candidates for judgeship. I didn't come out against anyone except one judge. I came out opposed to Judge Kephart. I adamantly said he should not be on the bench. He should not be on the bench because, and I laid out the reasons, and I'm not going to spend time here going over them, but there was backlash from that. I have a family member who's a clerk of the court and works in the RJC. She felt it daily. She was blackballed from that department and not permitted to work in that department. So I think what I'm trying to say is the bar governs itself, and I think as members of the bar and members of the judiciary and officers of the court, we have a duty, whether it's comfortable or uncomfortable, to police ourselves. And those of us that are in positions, either because of seniority or other reasons, to take these judges on, have an obligation to do so. Now, Andriea asked the question, well, what do you do? I will tell you the first time, and this is the judge that I took up to the chief judge, I had to appear in front of her on a separate issue where it was a contested issue, and I was tired of the bad rulings, and I made the decision. I was standing up to her. I wasn't going to cower down. So I left bail money with a friend. I did, in fact, leave bail money expecting to be thrown in for contempt.
And I just want to let the viewers know that you aren't exaggerating. It's happened before.
No, you can't. It has.
That's right. At least the most recent example that I'm aware of anyway is the one with the Justice of the Peace Conrad Haven. Well, former Justice of the Peace Conrad Haven. Moving on to the next topic, which is that of uncontested elections converting to retention elections, brought to us by AJR 14, and that the voters would have an opportunity to vote not to retain that judge, and they would later on be replaced by the Commission on Judicial Selection.
Well, I think that's close to what they call the Missouri Plan. I think it's a great idea for a lot of reasons. I still think that retaining still involves electing or politics, which is always troublesome. But I will tell you that as far as you want to take politics out of it by appointment, and I will tell you that the appointment process, at least in my experience, was more political than actually running, because the politics shrank down to a much smaller number of people, whereas at least with a public election, you have a chance to kind of even those odds. And so that's something that we forget. We just assume the appointment committee is all, nobody talks in their ear, nobody gets in their ear, there are no deals being made. I mean, absolutely not. It's just a smaller group of people, and they tend to be more people that are already in the judiciary. So, they get to select their peers. I get that. So to say there's not politics involved, well, that's not true. It's worse and it's smaller. But as far as electing people that you don't have any idea about how they'd be as a judge because you don't know, well, appoint first and then election to keep them. The public can understand when someone is not doing their job correctly, as in the case of Judge Humke. And so I like that hybrid idea. Do I think it'll get much traction? Probably not.
Over to Andriea.
Yeah, I still struggle with elections and that just in general. I think there always should be checks and balances occurring. It's just who is issuing those checks and those balances, especially of judges, and who's the one that gets to have the say. Or we just talked about judicial ethics. Is it the public I mean, people who are gonna vote to not retain are what, the few hundred people or 1,000 people that had a really bad experience with that judge. Like, that's not enough to make a statement. And we all know how people vote. They don't educate themselves as much as they should, especially on these little offices that they don't care about, judges, especially if it doesn't impact their lives. So I think I agree with you, Lance. I think it's a great idea. I just don't think it's actually going to ever, I don't think we'd ever see a judge removed because of it.
And that seems to be what happens in those states. I haven't looked at it very closely, but that's a great point. What do you think, Mel?
Well, again, I think it's better than no election at all. But I don't like electing judges. I think we have an uninformed electorate where the judiciary is concerned, and that's troubling. So a retention election, I don't have a problem with, because if somebody's bad, and you guys up north got to deal with Judge Humke, and it was rather public. We have so many here, it doesn't really get public. And when it does, it gets just a blurb. And, maybe then every 4 or 6 years, the bad gets more publicity. I don't know. I'm not opposed to it. It's better than what we have now. I don't like what we have now.
So we have two.
Hey, Alex.
Go ahead. Yeah.
Hey, Alex. Can I add one more point to that?
Definitely. Go ahead. Yeah.
And I know this cuts against what we said, but I think Judge Humke used to be a state representative. He had really high name recognition, and I think that he would have survived an election, honestly. So if he did have that retention model, I think he would have survived it, frankly. I think he would have said, well, I'm just a common guy, those are a bunch of eggheads, and they want me out, but I'm a guy for people. And I think he would have probably pulled 60%.
Wow.
Yeah. I don't disagree with you, Lance. I think and that was kind of where my point was, is that I don't think it would matter.
So even with all the press, because we read it down here, even with all the press, he would have still survived up there?
Yeah.
So this is
wow.
We've got two more here. These are not bills. These are just questions, 2 questions that I accepted. And the first one is, what are examples of alienating behavior that actually has an impact on child custody cases? And I think the frustration that led to this question is that people just don't really know what counts as alienation and to what extent the courts actually consider that under the best interest factors, starting with Lance.
All right, my knee-jerk reaction when I hear parental alienation, my knee-jerk reaction is it's somebody that's had a bad experience in court, that has grabbed a handful of studies to make a point about the family judicial system as a whole. So when you're saying alienation, why don't we just call it what it is? One parent not providing meaningful contact between the other parent and child. But when we call it alienation, suddenly we have this it sounds like pseudoscience. So we've got this theory, which I don't know is really helpful a lot of the time. So by calling it alienation, I think we marginalize people that would otherwise have a great argument. It's like when divorces, when people say, well, will you help me because my ex is, or my soon-to-be ex is a narcissist. Do you know anything about narcissist behaviors? Well, he's just an a-hole and he's treated you poorly. He's bad at the kids. We don't need to give it a diagnosis. And when they say that, I think, they've been reading some blogs, and so I need to kind of disabuse them of using that phrasing in front of the court. So preventing contact with your child and the other parents is horrible, and it is under the factors the court will consider when deciding how to award custody and visitation. It should be. I think calling it alienation probably doesn't do any good for those people that raise it, though I do know there is a minority that really believes it's a diagnosis. But ultimately, pragmatically, I don't know that it makes a lot of bread right now.
Okay, let's see what Andriea has to say.
Yeah, I totally agree, Lance. So parental alienation as a diagnosis or an analysis of a case is actually really debunked as bad science. So if you approach it from that way, and I've done the research on it, and because when people bring it up and they use those terms, I'm like, bring it, I got you. Like, I can argue on this all day long. So you have to reframe it. And that's exactly right. The best interest factor is which parent is more willing to allow frequent associations with the other parent. That's the factor that you have to look at, and you have to frame it in those words. Does it happen? Absolutely, all the time. Is it hard to prove? Yes. really, really hard to prove. You basically would have to have a spy camera in the other parent's house to record what it is that they're saying. If they're saying dad did this or mom did that or this, that, and the other, and then you have to have some sort of manifestation in how it affects the children. And at the end of the day, even in the cases where I have one parent clearly trying to keep the other parent away or reduce their time, they're still a parent. And apart from that, they're still mom or they're still dad. So I recently did a case where, that was kind of happening. So the judge did a really good job in just putting in better parameters. Like, here's what you have to do to respect the other parent. In that, this case specifically was a legal custody case. And it's, you cannot go to the doctor's appointment unless you have the other parent's consent in writing, or you don't go. So there's like ways to do that to stop it from happening. But I don't know how many people come in and say, oh, parental alienation. I'm like, stop, go away from Google Lawyer. Let's reframe the conversation. And here's how we need to make those arguments. But it does exist. And that's our job, right? As the lawyers, is to be strategic in how we're presented to apply to the best interest factors.
And Mel, take it away.
Well, I feel better knowing that Google Law School is operating up in Reno as well as in Las Vegas. I was starting to believe it was a Las Vegas thing only. And I refer to it as Google Law School almost daily now. So parental alienation and pathogenic parenting, the problem is it does appear in the DSM-5. It is a form of abuse, but what everybody is pointing to as parental alienation is not actually what parental alienation is. So I have seen one case of it where it was textbook pathogenic parenting. And it was not difficult. It was more difficult to get the judge to review the literature than it was to prove the pathogenic parenting. And even then, the judge didn't consider it because the judge determined that other factors could be put in place, like you were describing, Andriea, to overcome it. But this person went so far as every alimony check, both children signed or initialed that they saw the check was going to the other parent. Every child support check. When they got hit with attorney's fees, which, by the way, he's still paying me, he has 2 payments left, every check arrives with those children's initials on the check. It's been introduced in court, and the court recognized it, told them to stop. And so now only the one who's turned 18 initials those checks that show up at my office. So the other one I love is narcissist. You guys, they say that, and I'm like, do you know what a narcissist is? Do you know the actual diagnosis? Do you know the behaviors? And Lance summed it up. They're a-holes. They're not narcissists. That's the reality. A narcissist is an a-hole, but not all a-holes are narcissists. And most of the time, they just don't like each other in court. They're getting a divorce or they're in a custody battle for a reason. And that's not narcissism. That's adjusting to a new life, get the orders in place, follow the statute. And the one thing, and I don't know if this is what you meant, Andriea, or not, but I get so frustrated with judges trying to play social worker from the bench. Don't do that. Apply the law. And if they won't follow the law, then change the custody. But I am sick and tired of social workers from the bench.
So
I agree with that.
The second question, actually, you guys kind of went into, it was issues that the viewers had with the best interest factor parent most likely to facilitate contact. So since we kind of blurred into that anyway, I was thinking I would thank all of you very much for your time. It really does make an impact when they can see you, even just one-on-one. And when they can see all of you sort of engaging back and forth, it helps a lot. And so we appreciate your time, and we'll go ahead and do a round of goodbyes, starting with Lance White.
Well, thank you for doing this one, and thank you for the other panelists for taking a Sunday afternoon to do this. I think it's really important, and I think this is all about educating the public, which I don't know the public knows a lot about how court goes, especially family court, and so this is really valuable. And I think you guys contributed a lot. I think there's a lot to learn from just watching this. I'll watch it again, and I'm going to learn something from both of you. So thank you for appearing. And Alex, thank you for putting this on.
Okay, go ahead, Andriea.
Yes. First, thank you, Alex, so much for inviting me to be a part of this panel. And yes, thank you to the other panelists. I too agree. Lance, have learned a lot and really enjoyed this today. And I'm, would love to do more. And I think it really is important that we educate the public as much as we can from even just our opinions. A lot of what is what this is, and our perspective as practitioners, just to help the public out there, especially those that really just have no idea and are very lost and frustrated with what they're going through. And at the end of the day, I think that, 70% or so of litigants in family court represent themselves. So if we can help somebody from this hour just a little bit more in court, then I was very happy to be a part of
it. Thank you so much. And then go ahead, Mel.
Guys, it was a lot of fun being on here with you guys. I would restate what both of you did. I learned stuff today. It's always nice to talk to peers and to discuss the issues that are out there. And again, I stated this in different ways, but I think as members of the bar, as officers of the court, we have a duty to inform and educate the public. So I'm thankful for the opportunity, Alex, and I know we've talked about doing it before. I was glad it worked out this time. And again, thank you guys. I appreciate your time, Alex. I appreciate the forum.